n8871442. Your Honour, the situation that brings me before you today is my client, a 14-year-old Torres Strait Islander, has been charged with 106 counts of theft. Your Honour, my client was arrested at the scene before police proceeded to question him about a number of break-ins in the surrounding area. Your Honour, police allege my client confessed to these, although we only have their word for this, as no recording or notes were taken at the time. A statement was compiled later, but this has not been put before my client. Your Honour, confessions before police provide the appropriate cautions have been found to fall within the lead discretion as being too prejudicial. This allows Your Honour to exclude the evidence. I would also point out, Your Honour, that at this point in time, parents and legal aid had not been notified of my client's arrest, in clear contravention of the Police Powers and Responsibilities Act. I'll return to that in a moment, Your Honour. Police also claim my client made a full admission to all 106 charges laid before him. However, I believe that this confession was done in circumstances amounting to gratuitous concurrence. Your Honour, the questioning took place with one unmarked plainclothes police officer driving my client and another unclothed police officer around in the back seat, where the interviewing officer proceeded to ask, "Did you rob that house? You'd be good for that one too. How about that one?" To which my client replied, "Yeah, I guess. I'm not sure. How about that? Maybe." Your Honour, where my client was not sure whether he was responsible, police followed up with questions suggesting that it was done at the same date as another break-in at nearby. Your Honour, when my client responded to this, again my client went, "Yeah, I guess." Your Honour, my client's parents and legal aid had still not been contacted at this point in time, so the police was still in contravention of their responsibilities under the Police Powers and Responsibilities Act. Your Honour, after this interview, my client was returned to the precinct for a more formal interview which was recorded and with the support person present. At this point in time, Your Honour, I would like to draw your attention to section 401 of the Police Powers and Responsibilities Act, which states, this section applies if a police officer wants to question a relevant person and the police officer reasonably suspects the person is a child. Your Honour, my client clearly identified himself as 14 years old upon arrest. If I could read to you, Your Honour, subsection 2, part A. The officer must not question the child unless, before questioning starts, the police officer has, if practicable, allowed the child to speak to a support person chosen by the child in circumstances in which the conversation will not be overheard. Your Honour, I point out again that the support person is meant to be chosen by the child. The support person who my client actually had was assigned to him by the police upon his arrival at the precinct. Your Honour, the advice that this support person offered was simply to tell the truth and to answer all of the police's questions. They did not advise my client as to his right to remain silent. Your Honour, had my client been able to have a support person of his choice present, they could very well have told him not to speak to police. Your Honour, my first argument would be that these confessions and interviews are both involuntary and unreliable. I would suggest they are involuntary as he did not know the rights available to him. After that, I cite the Crown and Toffelau. I would also state that they are unreliable given that they arise in circumstances amounting to gratuitous concurrence. For that I cite the Crown and Lee. Your Honour, I would also point out that you have the discretion to exclude the evidence under Bunning and Cross, which provides a public policy discretion if the police have broken statutory requirements. Your Honour, as I pointed out earlier, the police clearly contravened section 421 when interviewing my client. Your Honour, I call on you to implement the powers that are at your discretion to to exclude the evidence of these interviews from trial. To further this cause, Your Honour, I will draw your attention to section 5 subsection E of the Police Powers and Responsibilities Act, which states, the purpose of this act is to ensure fairness to and protect the rights of persons against whom police officers exercise powers under this act. Your Honour, my client clearly falls within this category. Your Honour, this is further supported by the Fitzgerald inquiry. Your Honour, I implore you to exercise your discretion in the pursuit of fairness, so as my client can receive the trial that is fair to him. Your Honour, this is the main evidence against my client, and as such, I believe there is further weight added to this argument. Thank you, Your Honour.